other people are. So as a good teacher, I want to make sure that we start off with some learning objectives. TLW is an acronym used in schools to kind of give young people what the lesson is going to be about and what they should expect to be able to do at the end of the lesson. So for us, being the great attorneys that we all are, I want to make sure that we are all able to define and describe what school law is, be able to discuss why the practice of school law is important and influential on the practice of law, identify the general legal disciplines involved in the practice of education law, and recognize and discuss essential education law court cases, legal precedents, and legislation, and identify and discuss current and national state education law issues. And that's going to be part of the discussion piece that we have at the end of the presentation. If anybody has anything to add during the conversation, please, hit the raise hand button and we can discuss it. If it's something that you know is going to be a lengthy discussion or a hot button discussion, let's kind of wait to the end of the presentation so that we can give everyone else an opportunity to chime in or to form their own thoughts about a lengthy topic. So what is school law? School law is education law. I'm going to interchange between school law and education law, but in my mind, the meaning is one and the same. Education law is the collective education-related legal issues and considerations that arise out of the contracts, rules, regulations, and laws that control public or private education. When you're talking about education law, public education issues garner more notoriety, because obviously more people send their kids to public schools than private schools. However, private education legal issues are also a significant part of this kind of practice. State and local governments, along with guidance and support from the federal government, work in concert to provide citizens of their citizens with the desired outcomes for education. What's the significance of education legal issues? I find that as a teacher and a principal, I didn't feel like people really valued people didn't value what education and educators had to give to society. For me, I believe that education is significant throughout every part of what we do as a society. A quality education system is one that produces active citizens, and it's part of the DNA of the chain of a strong republic. How education goes the fortunes of people for generations to come. For education law, it influences and it reverberates through every aspect of American society, directly or indirectly. So we're talking human rights. If people are not educated, they can't participate in government. They can't, take advantage of whatever rights that they have. Definitely impacts the criminal justice system. I know some of you practice criminal law, and I can assure you that a vast majority of your criminal clients have had negative experiences or had a under quality education experience, which has led to them being involved in the life of crime. It even impacts environmental issues. Poor people typically, or undereducated people typically live in areas that have the most significant environmental risk, be it due to crime or violence or actual pollution related issues. It bears on race relations. A lot of your race relations or racial issues, your segregation issues in education stemmed from people having a fear or a lack of knowledge of other people and choosing not to even begin to learn about them. The economy, the majority of uneducated people make up the majority of the lower socioeconomic groups in most societies. Politics, we all know that it definitely influences politics. When you look at the source of the money that's used for a lot of education initiatives and why those initiatives are being pushed, it gets back to politics and even foreign policy. So we all know around the world, different countries compare education systems in the 60s when the United States thought that the 50s and the 60s during the Cold War, when the United States thought that the Soviet Union was surpassing them educationally, it pushed us to make some really interesting foreign policy decisions and domestic policy decisions as a result of that feeling. So I think that the influence education has on the entire field of law is very important, as well as its influence on society. And it's one of the reasons why I decided to make that a part of education law, part of my practice. If you guys would give me a minute, I want to kind of move, hide my face so I can see. All right, so in education law, there are two main actors, one being the federal government, and I apologize for my error, I just saw it, but the federal government is one of those actors, as well as local and state and local governments. The federal government actually has no direct oversight over education. I know that they make a lot of policy towards education. They draft and implement a lot of legislation, but as we'll get into this presentation, you'll see why. But they don't have any, the federal government doesn't have any oversight over local education. They have influence via financial funding, but no direct oversight of public education. And that's because the Constitution doesn't expressly mention education. As we all know, the 10th Amendment provides that the powers not delegated to the states, delegated to the United States by the Constitution, are reserved to the states respectively. So again, there's no federal oversight in education, of education. However, the 14th Amendment does require that all states provide any person within its jurisdiction an equal protection of the laws. So the federal government does have the power to intervene in cases of legally sanctioned discrimination, and we'll get into some case law about that. Brown versus the Board of Education provided that ability to intervene. It provided the executive branch with the legal precedent for enforcing equal access to education. The federal government also has the ability to provide safeguards to the constitutional rights of teachers and students, and we'll see some of that as we go through some of the cases and the law. One of the things that influence via financing by the federal government allows them also to do is provide data collection and research. They're obviously providing data collection and research to support the initiatives that they want schools to move forward with. So again, that's one of the things that the federal government, one of the responsibilities they assume in their role. The federal government also identifies problems in education at the national level. So obviously the data collection and research, they look at it as a whole national, and they use that to also give information to states and local governments to make decisions on. The federal government also provides states with funding for educational programs on a conditional basis, which means that states can receive federal funding for education provided they meet the requirements outlined in certain sections of titles of the federal acts put forward. State and local governments are the ones who exercise oversight over most aspects of public education. State responsibilities include providing and allocating funding for public schools. That's always a hot button topic. If you listen to what's going on in the news every school year, once the legislative session starts, not the school year, there's always some issue with funding public schools, either moving around MFP allocations. MFP is a minimum foundation plan that the state uses to generate revenue forward to provide for schools, to provide money and funding for schools. States also set the standards for assessments, school standards and curriculum. They oversee special services for students with disabilities and other challenges. We're going to spend a lot of time talking about Section 504 of the Individuals with Disabilities Act of 1973. I'm sorry, not the Individuals with Disabilities Act. But the state's also licensed and accredited all public and private schools in the state, including charter schools. If anybody has questions about the difference between charter schools and traditional public schools, we can get into a conversation about that at the end of the presentation. The state typically oversees the licensure of teachers and other staff members in public schools. That has been a very recently, over the last few years, that has been a recently interesting topic. As we get more involved in school reform, the less requirements the state put forth in having teachers certified and other staff members certified to do what they do. And again, the state also provides funding. Local governments are the ones who actually operate schools, implement and enforce the state laws and policies, develop and implement their own educational policies. So although a lot of school policies are aligned because of the state rules, school districts and their boards do have the ability to make some movement in those decisions or in those policies and implement their own policies. Local government hires and supervises professional teaching staff, and they also raise money to pay for schools, usually through property taxes plus special bonds. That piece gets hairy because obviously some school districts, some areas are more affluent than others, and although they all get some sort of state funding, that supplemental funding provided by the local government is what widens the achievement gap. Schools that have more can purchase more, have more resources to provide better learning opportunities, whereas schools that are in low income, high poverty areas don't have the same local government money, which creates that achievement gap amongst young people. So let's get into some of these landmark education cases. I think the most important aspect of this particular part of the presentation revolves around how education impacts and the decisions that are made about education impact every aspect of law and every aspect of our society. The first case I'd like to discuss is Plessy versus Ferguson from 1896. It dealt with the Equal Protection Clause. It legalized segregation based on race by establishing a separate but equal doctrine. I know we all are familiar with that. The case stemmed from an 1892 incident, a Louisiana incident, in which a gentleman by the name of Homer Plessy, an African-American gentleman, challenged the Louisiana law that allowed for separate seating on train cars between Blacks and white people. He refused and based his claim on it violating his constitutional rights. The Supreme Court disagreed with him and said that they disagreed with his argument and ruled that a law is constitutional if it merely implies a legal distinction between whites and Blacks, and it wasn't unconstitutional. That ruling, that holding set the wheels forward for Jim Crow and racial segregation throughout the South and the rest of the country. It pretty much condoned separate public accommodations based on race, and that severely impacted what was going on in schools. Our next major case. And let me say this is not an inclusive list. These are just a lot of the cases that I thought if someone would need to be familiar with if they were interested in a school law practice. The next case is the famous Brown versus Board of Education from 1954. This particular case overturned the separate but equal document because it violated the Equal Protection Clause. Students had been denied entrance into certain public schools based on Jim Crow laws. And we had a group of people that really wanted to make sure that they highlighted how the segregation affected Black children. Initially, the plaintiffs were denied relief in the lower courts based on Homer versus Ferguson. Plessy versus Ferguson, I'm sorry. Plaintiffs argued that such segregation violated the Equal Protection Clause. The Supreme Court unanimously ruled racial segregation in public schools, racial segregation of children in public schools was unconstitutional because the separate but equal educational facilities were inherently unequal, and they subsequently overturned Plessy versus Ferguson. That decision mandated that the desegregation of public schools and gave the executive branch a legal precedent for enforcing equal access to education. So that decision allows schools, allowed the federal government the opportunity to have some, although little, oversight over schools when it came to segregation. It has been interpreted to give the federal government the power to intervene in cases of legally sanctioned discrimination, like the segregation of public schools across our country. It mandated equal access to education for students with disabilities as well. I don't think most people realize that. And according to a lot of legal scholars, I'm sorry, that's a wrong note. All right, I'm gonna move on to my next case, which is Engel versus Vital of 1962. In Engel v. Vital, the Supreme Court struck down a New York state rule that let public schools host a short voluntary non-denominational prayer at the beginning of the school day. Religion is going to be a reoccurring theme in a lot of these cases, simply because a lot of communities chose to try to implement their religious beliefs while children were in school. We all know that there's a wall between church and state. And a lot of this case law has to do with communities trying to implement or support or deny, inhibit religion. Excuse me. So in Engel, the court struck down a New York state statute that let public schools host a short voluntary non-denominational prayer at the beginning of the school day. A group of organizations joined forces challenging the prayer, contending that it violated the Establishment Clause of the First Amendment. The New York Court of Appeals rejected their arguments. The reasoning in Engel was applied in the Abington School District versus Shemp, where the court struck down a Pennsylvania policy that required all students to read from the Bible at the start of the school day. The school district sought to enjoin enforcement of the statute, but the district court ruled that the state violated the First Amendment. And even after the statute had been amended to permit a student to excuse himself from the prayer, again, the major thing is the Establishment Clause. Those kind of rules violate the Establishment Clause. As of lately, I haven't been aware of any recent rulings or things other than the voucher issue. And our state just had some voucher issues a couple years ago. But this hasn't been something as of late that has been an issue, but it can be at any time given who's in political power and who wants to try to take another bite at that particular apple. We also have Tinker versus Des Moines. This is a school law limiting speech or conduct. Schools can't limit conduct unless the school can prove that the conduct or speech is materially and substantially interferes with school operations in order to justify their limitations. This is an interesting topic for me because I know what the law is. However, I also know how schools operate and how disconnected the school building is from actual legal precedent and legal concepts. A lot of times principals are not trained as thoroughly in what different legal precedents mean for them at the school building level. This particular case is its notable impact on First Amendment jurisprudence regarding distinctions between conduct and speech, as well as for its extension of free speech protections to students. In this case, public school students in Des Moines, Iowa, organized a silent protest. The protest had to do with the Vietnam War. The students were wearing armbands to protest this, to show their stance on the Vietnam War. They planned to wear black armbands to school, but the principal found out and told the students that they would be suspended if they wore the armbands. Despite the warning, students wore the armbands and they were subsequently suspended. The parents obviously got upset and sued the school district for violating their right of expression and freedom of speech and sought an injunction from the school district disciplining them. A U.S. district court sided with the school, ruling that wearing the armbands may disrupt learning. The students appealed in the U.S. Court of Appeals, but they lost. They took the case to the Supreme Court in 1969. The court ruled by a 7-2 decision in favor of the students. The crux of this particular case is that although we're talking about children, a child's rights don't shed their rights at the schoolhouse door. A lot of times, although schools have the ability to limit children and limit them for their own protection, it doesn't mean that kids have zero rights and that schools can do as they want when it comes to their freedom of speech. And so I think when I look at my career and I look at how some of the things that I've seen in different schools happen, be it from teachers or school administrators, I think this is a very, very, very important legal case for educators, because it really sets the stage for coercion and preventing kids from having unjust influence or from not being able to exercise whatever religious beliefs or thoughts or ideas or expression that they've been taught at home. We also have Lemon versus Kurtzman from 1971, and this was a different sort of establishment clause challenge where the controversy dealt with a statute providing financial support for teacher salaries and textbooks in parochial schools. So again, we have that idea of religion in schools. The Supreme Court articulated a three-prong test, which we all know is a Lemon test, that determined whether a particular statute or law violated the establishment clause. The Lemon case was a consolidation of two separate First Amendment challenges to the Pennsylvania and Rhode Island statutes that provided state aid to parochial schools. The Pennsylvania statute provided funding for non-public elementary and secondary school teacher salaries, books, and instructional materials for secular subjects. Rhode Island statute provided state financial support for non-public elementary schools in the form of supplementing teacher annual salaries. The district court granted state officials motions to dismiss this case, but in Rhode Island case, the district court found in favor of the appellants and held that the statute violated the First Amendment. Again, when you look at the time period, 1971, when this happened, this was right after desegregation was nationally ordered. And a lot of parents who did not want to integrate their children into schools that other children of other races attended chose to put their children in private school instead. So around this time, a lot of new schools started popping up. And if you look at the research, the populations of public schools started to lean more towards all Black, or not all Black at the time, but the Black enrollment started to increase while the white enrollment in public schools started to decrease. So a lot of this was motivated by people not wanting to integrate public schools, which is still a reoccurring theme today, albeit it's in a different form. People are using different methods to keep schools segregated. It's more of a socioeconomic status driven than race, which obviously eventually leads into a conversation about race. We have Wisconsin versus Yoder from 1972, which was a landmark free exercise clause decision. Among the litany of public school cases from the Warren and Berger eras of the court is this case, Yoder. Wisconsin mandated that all children attend public school until age 16, but a young man by the name of Jonas Yoder, an Amish young man, refused to send his children to school past 8th grade. He argued that his children didn't need to be in school that long to lead a fulfilling Amish, I use that, I want to emphasize fulfilling an Amish life of farming and agricultural work, and that keeping his children in school for such a length of time would corrupt their faith. So he's making this decision not just because he doesn't want his kids to go to school anymore, but it's based on his religion and his faith. And therefore, that rule compelling him to send his children past that school actually inhibited his ability to practice his religion. The Supreme Court unanimously agreed, they sided with Mr. Yoder, saying that the values of the public school were in sharp conflict with the fundamental mode of life mandated by the Amish religion. And it carved out an exception to Yoder and others similarly situated. Another case that actually surprised me when I first learned about it was San Antonio Independent School District versus Rodriguez. Again, as a principal, I don't think that we were versed enough in school law and what some of these court decisions meant to us, but it was shocking to, it was honestly shocking to realize that, there wasn't a constitutional, education wasn't a fundamental right. In San Antonio Independent School District versus Rodriguez, the court rejected the plaintiff's argument that the Equal Protection Clause mandated equal funding for schools. This was a case where the San Antonio Independent School District.
So if you can hear me, I can't hear you.
You can't, am I mumbling or you just can't hear me? Am I clear now? Can everybody hear me?
Yes, I can hear you, Averil.
Okay,
yeah.
I appreciate that. Thank you.
Okay.
In San Antonio Independent School District versus Rodriguez, the Supreme Court held that the financing of the system, which was based on local property taxes, was not unconstitutional and not a violation of the Equal Protection Clause. They held that the Texas school financing system was unconstitutional under the Equal Protection Clause because it discriminated. It wasn't unconstitutional. The discrimination that the plaintiffs alleged that was occurring based on wealth, it just wasn't, it didn't rise to the level of being unconstitutional. Again, this is something that for me was very interesting to digest because in this particular case, parents were seeking to use their argument. The argument was pretty much that because the funding system of the state of Texas provided that some districts got more, some school districts had more resources because of the local taxes from their area than others. They felt like that it was unconstitutional, that their kids weren't being treated the same way as children in affluent school districts. And I also want to point out that the families in this particular case, the plaintiffs were Hispanic people. And so again, it was a group of Hispanic minority people, lower socioeconomic status people attempting to even the playing field in education for their students by bringing this action. But as obvious from the brief, the Supreme Court disagreed and said that it was constitutional for different school districts to have, or to be able to generate more money than others in order to provide the resources for their schools. We have the Board of Education v. Raleigh from 1982. In this particular case, a New York public school refused to provide a sign language interpreter for a deaf student. We do have a few cases and definitely some legislation that speaks to students with disabilities. This is an ongoing theme. A big part of my practice right now is dealing with families who have issues with how their 504 accommodations are being met, and their IEPs or individual education plans via special education being met. So this case is one of the cases that I thought was important because it's one of those cases that it provided case law that related to special education. As I said, a New York public school refused to provide a sign language interpreter for a deaf student, and it was based on the fact that the teacher felt, the teacher in the school, excuse me. I'm sorry, everybody, my cup is leaking. I'm gonna wipe my face. But the teacher in the school believed that the child was doing fine and didn't believe that the child needed a sign language interpreter. The child's parents obviously disagreed, and they sued the school on behalf of their child for violating the Education of All Handicapped Children Act of 1975. A district court ruled in the student's favor, holding that while she was doing better in school than the average child with that particular learning disability, she was not achieving her full potential because she was unable to understand much and would benefit from a sign language interpreter. This is one of the first cases that actually started to add on specific rights to students with disabilities. We also had, in 1982, we also have Playler versus Doe. And this was a class action lawsuit that was filed on behalf of school-age children of Mexican origin residing in Texas, who couldn't establish that they had been legally admitted into the United States. So obviously one of the hot button issues today is immigrants, and we all know our country's current policy of separating immigrant children from their parents at the border. I'm saying that to say that this is not a new, based on this case, these are not new issues, new developments in people's attitudes, but something that's been long-standing. And this was an educational case that I thought would give people an insight as to this particular issue. The Supreme Court struck down state statute funding for education to immigrant children living illegally in the United States, and the municipal, not a Supreme Court, a state court local court struck down a state statute denying funding for education to the Supreme Court did strike down the state statute denying funding for education to immigrant children living illegally in the United States, and a municipal school district's attempt to charge an annual $1,000 tuition fee to each student to compensate for lost funding. I believe in this case, what they were trying to do with that piece was they were trying to, because they figured that illegal aliens weren't citizens and didn't have the right to go to school or to get a free education, that they would try to recoup the money lost by charging them a fee, charging them tuition. Obviously, if they're low-income immigrants, their ability to pay would not be not high. So, it was found district court found that the increase in enrollment in Texas public schools was primarily attributable to the admission of children who were legal residents. And the court concluded that people living in the country illegally were entitled to the protection of the protection under the Equal Protection Clause of the 14th Amendment, and that the Texas legislation violated it. A court of appeals affirmed it, and the Supreme Court agreed to hear the case, and the case was decided with Texas versus certain named and unnamed alien children. Again, I think this case is important because it's still an issue. The education of immigrant children is still a major issue. It still generates negative feelings to this day. One of the most important cases is up next. We're talking about New Jersey versus TLO from 1985. And it deals with the students' Fourth Amendment protection against unreasonable search and seizures. This is a very, very interesting case to me because of the current climate in education. Via COVID, everybody is now participating in school. Most places are participating in school through a hybrid model of on-campus and in-person learning, or on-campus learning, or virtual learning. And what has been discovered is that a lot of schools started their online programs, but they didn't adjust what is going on, their rules for online learning. So in Jefferson Parish, we have a situation where a young man was suspended from school because of what a teacher observed in his bedroom where he was participating in school. She observed a gun, and the young man was subsequently disciplined. It caused a major uproar. It even made the national news, although it's a state case. I'm sorry, a state occurrence, but it made the national news because I think people are really leery about schools having the authority to influence what happens in their personal home, in their homes. So this particular case is one that relates to that. It's a little bit, the facts are a little bit different, but at the end of the day, I think it's something that's going to have to be addressed based on the standards established by this New Jersey versus TLO case. In this case, the Supreme Court ruled that the public school administration can search a student's belongings if they have reasonable suspicion of criminal activity. In a nutshell, the case revolved around a principal catching a young lady smoking in the bathroom and forced her to let him search her purse. The young lady's purse is searched, and it's discovered that she had marijuana, cigarettes, or something, and she was subsequently, suspended from school, and criminal charges were brought under her. Her family argued that his search was illegal, and that the evidence of his search shouldn't be used in her prosecution. The New Jersey Supreme Court reversed, I'm sorry, let me back up a bit. In this case, the child was charged with possession of marijuana and expelled from school, but before the trial, her attorneys moved to suppress the evidence discovered in the search, but their motion was denied. The Juvenile and Domestic Relations Court of New Jersey found her guilty and sentenced her to probation for 1 year. On appeal, the Superior Court of New Jersey Appellate Division affirmed the denial of the motion to suppress evidence. The New Jersey court reversed, holding that the exclusionary rule of the Fourth Amendment applies to searches and seizures conducted by school officials in public schools. The Supreme Court ruled that New Jersey and the school had met the reasonableness standard of conducting such searches at schools. I know for me, in a practical sense, as a principal, I've come across several criminal situations that occur in schools, most of which are drugs or weapon searches, where because we are not the police, we had the ability, all we needed to have was a reasonable suspicion, which obviously can be easily met. That standard can be easily met, but I think it does allow for a safer, in practical sense. It allowed me to more safely operate the school. If we had to meet a standard that the police had to meet, Lord knows what would be happening in schools today. Our next case is United States versus Lopez, and this is really a Commerce Clause case. In this case, the Supreme Court declared that the Gun-Free School Zone Act was an unconstitutional overreach, as the case was seen by some experts signaling a shift in the court's interpretation of the Commerce Clause of the Constitution. A young man named...
we do have one question. I was gonna, if you don't mind.
Yeah, we can address that question.
Okay. Okay. Stacy, if you want to unmute.
Okay, I'm sorry. I was literally talking and forgot to unmute. Yes, it was actually going back to the case you mentioned in regards to, I know it's, I guess, one of your current cases, and I guess this goes to what I found as a trend within education. I've noted that there have been issues where students have actually been suspended from school based upon acts that were on Facebook or some type of social media. And then the issue was then brought to the actual physical school building, but it was based upon what they found on social media. So I guess my question in regards to the case you were mentioning, since that was an online course and there is no actual physical connection to the school, what was their actual basis, just out of curiosity, to justify the suspension? I mean, like, what policy or what law did they hang their hat on to justify that suspension?
Well, that's actually the heart of the issue itself. The school suspended the young man based on a on-campus policy of zero tolerance for weapons, and their suspension actually was based on the teacher observes him take a pellet gun from his younger brother, who was also in the room with him, and if a child brings a pellet gun or any kind of weapon to school, almost every school has zero tolerance policies, right. And the kid would be suspended for it. However, this is the distinction between what you're asking and what actually happened in this case and the TLO case. In the TLO case, the young lady was doing, she possessed those drugs on the school campus. Right. You don't know what she can do. So it was genuinely a safety concern. And again, it was reasonable because he caught her smoking for him to go ahead and search her purse to see if she had more. She could have had more and given it to somebody else, and, somebody else ODs or something. I think when you talk about kids having issues or things happening on social media outside of school, and those things, therefore, are addressed by those same kids when they get to school, I think it's a little different. Now, there are issues that are arising with schools actually monitoring children's out-of-school activity via social media and then trying to bring those issues to school. The difference is some things are school-related, school functions, school-sponsored events. As a principal, if a child got into a fight after they left school, either on the bus or walking from the bus stop home, we still had the authority to enforce them because they had not, returned to their houses. But social media makes it such that schools and school leaders have to be more abreast of what these cases actually mean in today's context. And again, as I said twice already, I just don't think that a conscious effort is being made to train principals on how to use these decisions to make these court cases, these issues, to make decisions about what happens in their schools now. So because of that, you get a lot of schools that are overreaching. I think it's definitely an overreach in what happened to that young man in Jefferson Parish. The child wasn't pointing the gun. He wasn't using a gun to menace his classmates, or he wasn't playing with the gun while he was online. He simply took it from his brother and placed it on a bed or on a table or something next to him. And the teacher could still see it. And that's why he was suspended. And so I think the difference is when a kid is using social media or does something outside of school, and it has an impact on school. But if schools are allowed to reach in your house and discipline your child for things that you condone, I just think we all in for a long way to go if that's upheld. Right now, I know that the state legislature, I know that the House unanimously passed an act in honor of that young man, which gives parents more due process rights when it comes to online and virtual schools. But I think the major issue for me with the Jefferson Parish School Board decision is that you created an online learning experience, but you're still trying to use your on-campus policies to manage.
Hold students accountable.
Yeah, and in a nutshell, I just feel like the school district was being lazy. They weren't very thoughtful in how they outlined their program. I think whenever you do a new initiative in a school, you have to consider what policies and procedures you need to either implement or fine tune before you do it. And that particular incident, and let me say this, he wasn't the only young man that happened to. Another child. I actually think there's 2 other children were also disciplined for similar things. And again, it's about children doing things that their parents allow, believe in, condone. But as a result of it being disciplined by the school, I think that's just a major issue for me. Does that answer your question?
It does. I'm just, like I said, I'm just curious because in my mind, I'm thinking, normally if it's a gun issue, they typically look at expulsion because then you do have to go through the full process. And what I've found is that oftentimes not only are school administrators not abreast of education law like they should, the school board members aren't either. And so it becomes problematic.
The school board members are, and I'm just being honest. I hope there are no. I hope if there's a school board member on this on this conference, on the Zoom call, that they forgive me. But in my honest opinion, school boards. I've always found that people assume that schools and education is purely about children, and it's not. And I find that a lot of school board members are going to parrot whatever they feel like the popular stance of their constituents is whenever issues like this arise. So a lot of the school board members, and it actually transcended race, because one of the more vocal school board members I've observed in that particular case, obviously I can tell I've been following this case, but he's actually a young African-American man. But I just think that he does not understand the overall implications if we allow schools to reach into our homes via online learning. How far do you think the police will go? I just don't think that they understand the big picture of what that one act did. And to also add, the school board attempted to put a Band-Aid on the issue. The child was originally recommended for expulsion, and in those instances, principals don't have the latitude not to recommend expulsion. So that child was actually initially recommended for expulsion, and then the school board commuted his expulsion to I want to say a 2-day or 3-day suspension or something, which is still unfair.
Exactly.
So, does anybody else have anything to add before we move on?
We do have one question that says, hi, can you give a brief description of a tribunal hearing?
In a school, a tribunal hearing is a situation where you have different constituents of a school. So you might have a school, an administrative representative, a teacher representative, and a student representative, for lack of a better terms, that evaluate certain discipline infractions. I've never seen it where they do it for all, but they evaluate certain, they hear the evidence for certain, high profile school incidents, and render a decision. The benefit to that is that, you have involvement in it, but I think you also have to consider whether or not the rule is one of those rules that contributes to the school to prison pipeline. I don't know how many people on this call actually understand how similar schools and prisons operate, but there's a concept in the education law, that school to prison pipeline, where school policies, school behaviors, and I'm talking about just things that the school does, mimics and puts kids on a pathway to prison. They conditionalize them to that they give, through education, they give an experience that is akin to prison, which minimizes a child's impression of whether or not not whether or not prison is for them, but it makes it more likely that that child will precipitate to prison.
Mr. Theory had a question. That was his question.
Yes, sir, Mr. Theory.
Hi, I was interested in, they present evidence and the student at issue can present defensive evidence as well. Couldn't that be used later? Can that be used later in the criminal proceeding?
Most definitely.
Okay.
Most definitely. Now, let me say this. I haven't personally seen an incident where a school has turned over well, actually, yes, I have. I just handled a case with an adult, but yeah, I have seen an incident where that has happened. It's not something that happens very often. I think the bigger picture is allowing, I guess, because of that standard of reasonableness that schools have to meet in order to do their investigations and search kids and so on and so forth. Evidence is easily obtained in the course of a school investigation. I think the issue is school leaders don't understand that, you know, their method of doing it and shortcuts, so on and so forth, opens a child up to it creates a stronger case for children who commit criminal acts at school. When those things happen, the school does their own local investigation, and then obviously the police are called out and they do their own investigation, and the police do look at the evidence that school officials gather. Again, I think the training that needs to happen for principals, it's not an in-depth enough training, legal training. So when you are trained to be a principal, and I was trained, I received my licensure to be a principal, I want to say in 2007 or 2009, I was certified to be a principal. But at that time, I had only taken one school law class that didn't, really delve into the crux of what my actions as a school leader meant for the school, for children, for families, so on and so forth. So I think, to answer your question, I think the bigger issue is having school officials understand how important it is to properly do their job. However, not to unnecessarily subject children to the criminal justice system. Again, that relates back to that idea of the school to prison pipeline. Does that make sense to you?
Yes, it does. Thank you.
Children are allowed, well, families, whether it's a tribunal or a regular hearing, student discipline hearing, students and families have the opportunity to, present evidence. But I think when it comes to those tribunals, because tribunals are mostly school-based personnel who will have access to more and have more knowledge about what's going on, the opportunity to get more incriminating or damaging evidence on the criminal side is greater than when a child goes to an independent hearing officer and presents the case. The independent hearing officer only knows what they have right there. In the sense of a tribunal, those constituents that make up the tribunal pretty much have more insight and more knowledge about what's going on, and are able to gather more information about, more evidence about what's going on. Does that answer your question, sir?
I disallowed his talking. We have one more question from Stacy. Let me see if I can put him back, though, because I may be able. Yep, I can put him back. Mr. Theory?
Yes, I'm through.
Okay.
You answered my questions. Appreciate it.
Ms. Stacy, you have something to add?
Maybe she raised her hand accidentally.
All right.
Okay.
I'm sorry. Can you hear me now?
Yes.
I'm sorry. I was talking. Totally had to take it off mute. But going back to that issue of tribunals, especially coming from a state with a lot of Native Americans, a lot of school systems have those tribunals, whether they're using teen courts. I've seen, schools get really heavily into that, or they have those other bases where they're using small group subcommittees. I've seen school boards do that. What I've told students as an academician who is also an attorney, that you be mindful of what you go into in those, because like you all were just saying, the things that they discover openly oftentimes can be utilized in ways that criminally that may not be to their best interest or their or advantageous, because typically they do have them sign forms, waiving certain rights and things of that nature. So I'm always leery when if those situations are not, this is the final decision, or the final mechanism in regards to this issue, and that it will be sealed later because they don't have to adhere to all of the same
standards,
procedural issues that a court has to, but the courts can utilize anything substantively they receive. So
exactly.
Yeah.
I think my personal experience, and this was prior to me being a lawyer, it was just my feelings out of fairness to children. And again, I think this is what I add when you talk about my personal experience adds to when you talk about the practice, the school and education law practice. I prided myself on always making sure that whether children and families knew what their legal rights were, that I didn't trample those and I didn't hide the ball from them regarding that. That is what actually happens a lot of times. And again, whether knowingly or unknowingly, schools do take advantage of a family's lack of knowledge about the rules. And because people trust that schools are going to do what's right for their children, they allow them to, which leads to what you just commented about. But I think for the most part, again, it comes with training and making sure that people understand the ethical, issue with, not making sure that people understand, what they can and cannot do or what they have to do when it comes to schools. I would always tell kids that I spoke with about issues. I mean, I had to always ask them, their side of the story. But if a child didn't want to talk, or if a child wanted his parent to be in the room when they talk, I didn't get upset or try to add additional punishment because the child refused to participate without their parent, or even in the criminal law area, you have a right to remain silent. That's not actually enforced when you talk about those kind of issues that happens in schools. And so kids do say more than they need to say, which does eventually sometimes lead to kids being prosecuted and having an additional evidence being developed on the criminal side because of that. I just think in public schools, I'm sure we've all heard about the cases in Florida where the children, 6-year-olds, are being handcuffed. Again, people naively believe that what happens in schools is strictly about what's in the best interest of children, but a lot of times it's not. And I know from a criminal justice standpoint, even with my own children, I've had to make sure that I've taught them and trained them that, you understanding your rights as a U.S., as a citizen under the Fourth Amendment does have, weight in school. It's just like the other case we were talking about. Kids don't shed their rights at the schoolhouse doors, no matter how much adults, school administrators, or school boards believe that they do. And again, a lot of my work in school law now has been advocating for parents and families who have been wronged, especially when it comes to education. It's been something that's, it's ongoing, and it's always, every time I get a call, it's surprising what I learn and find out about what's happening in school districts as it relates to that. Before we move on, I at least want to touch on a couple of these significant laws. And I think based on the questions people have been asked, I'd like to focus everybody on I guess that I'm going to move to that Individuals with Disabilities Act of Education Act of 2004, IDEA. That's the federal law that governs special education. And we also have the Section 504 of the Rehabilitation Act of 1973. Those are two very, very, very important laws in public education. And again, most of the work that I do have been from the standpoint of advocating for parents whose children's rights have been violated as a result of schools or school districts not providing what children are supposed to get as a part of these particular acts. Another important act is this McKinley-Vento Homeless Assistance Act of 1987. I'm sure you guys have heard of, there was a family when I first moved to Baton Rouge that had illegally put their children in school in Central, and it became a big news issue, and the children were put out of school, and I believe the mother was threatened with prosecution. on a national level, there was a story a couple of years ago about a Black lady who went to jail for illegally enrolling her students, her child in another school. The McKinley-Vento Homeless Assistance Act is important because it allows homeless children, it provides a legal definition of what a homeless child is, and it also it mandates that schools allow those children to enroll. A lot of times schools or school districts that are not seeking to diversify or that are not trying to allow immigrant students or non-white students in their schools, they use the fact that the kid doesn't live there or the kid doesn't have the proper documents or the kid is not being enrolled by the parent of record, so on and so forth. This particular act is what governs a school's actions by that. And I've had situations where parents have complained about, not being able to enroll a kid in school. And when I listen to them talk about the circumstances, they're living in a car, or they're living with another family, or the child is living with a friend and his family, and they can't get the kid in school. Schools are aware, they definitely should be aware of a child's homeless status. And that's that's an automatic enrollment if a child comes to their school with that. These other laws that I've listed are very important, but I think of everything that I have on this page, those three are, and also Title IX of the Education Amendments of 1972. We all know Title IX deals with gender equity. However, the recent expansions have also expanded rights for children that are whose sexual identity is of issue. So trans children are allowed to use use locker rooms and restrooms that align with their gender identity. And I think I've witnessed as recently as last year where people have said to children, you're a boy, you're biologically a boy, I'm gonna call you by your name. Under Title IX, there are expansions. Schools and school personnel have to even address children by the name, the gender name that they choose to be called, even if that child hasn't had a legal name change. So I think in a nutshell, what I'd like to say about this practice is it's needed. More people in the practice is needed. There's a very, very small minority of number of minority practitioners in this area. And I think I'm one of the few former educators that actually practices in this area. And so if anyone is interested in this kind of practice, I would love to help. No questions asked. I'm always interested to talk about these kind of issues. And if you'd like to reach out to me, this is my contact information, and I'll leave this up. If anybody else, if time permits, and if anybody else has any other questions, I would love to be able to address them at this time.
Does anyone else have any questions? We still have 5 minutes, so yeah.
Oh, I thought we had less time. I was trying to rush through.
Oh no!
I see somebody's hand is raised.
Okay, let's see. Okay, here we go.
Hi, it's me again. This is Stacy. I had a quick question in regards to, have you had any cases in regards to the ACT? I know that there has been a growing trend for colleges and universities to start using their own placement tests. However, that still has not trickled down into secondary education, saying the ACT, even though we all know that it was never designed for the purpose that educators are using it for, but they're still using this to determine eligibility for players and students. And what you're finding is that you're having, especially a lot of Black athletes, if they go from a 12 to a 25, legitimately where they could have made the 25 the first time. I'm not saying that some cheating doesn't go on, but the ACT admits that they do not have any way or mechanism to actually definitively say you're cheating, but they're saying there's no way a person can go from a 12 to a 25, which is so not true. So my question is, I guess, have you dealt with any cases like that, or have you seen any trends? Because I know this issue as we continue, is going to become even bigger, especially when they're now having to have individualized proctors in this process.
So actually, I just addressed an issue for a family with the ACT about 2 months ago. There was a young man that took the ACT, a highly intelligent young man who he had taken the ACT. He had taken a previous ACT test at the University of New Orleans, but when he took the test, he was unable to finish because there was a fire alarm that went off or some disruption that caused the testing site to shut down. So when he takes the subsequent test and he scores, I want to say he scored a 26. The ACT flagged his score because they said that students, he went to St. Augustine High School in New Orleans, which is an all-black, all-boys private school. They said that because of the school where he came from, his score was invalidated, and he gave the parents some options. The issue with it is the ACT is given under two separate conditions. He, in both of those instances that I just described, was taking it in his private capacity, for lack of a better term. The Louisiana State Board of Education implemented a rule a few years ago that required children to also take the ACT as a part of state testing. So I think how that works out, is how ACT addresses it depends on what capacity you take it in. For this particular young man, we were able to, ACT sends, when they send you the response, they give the parents some options. And after I talk through each option with the parents, because of this young man's academic ability, that family decided just to go ahead and take and do a retest, let the score go and take take another test. I think had that same incident happened at the school, I think the school would have had to intervene and provide that. I apologize if everybody can hear the train outside my office, by the way. But had that same situation happened at the school, then I think the school would have had to intervene and provided some kind of relief as well. It was a little bit harder fighting with the ACT because obviously they're a private business, but if the school is giving it, and it's a school-sponsored test, it's a state, it's a required state test, then I think the implications would have been different had it happened on the school's watch.
Well, I know with ACT, and the only reason I know this is because I had one of my my former students have that as an issue. He's an athlete, smart young man. Long story short, most students who take the test for the schools, because that's implemented throughout the country, because they found that the U.S. Department of Education found that most states' graduation exams statistically were not valid or reliable. So then they said, well, as a measure of progress, we'll mandate everybody use the ACT. So fine, it's given throughout the U.S. Most students don't take it seriously. It's when they spend their money in their junior, senior year, their senior year, now they're taking it more seriously, and it shows. But again, even in those situations, because they take into consideration the school you attended, I don't see where they have any legal justification, even statistical justification, to say because of that, this is why this student could not possibly have been privately tutored and made the score. I think that their process is inherently racist because they tell those students that you take the test, if you pay for it, when you pay for the test, you are actually automatically waiving your ability to sue. If you use one of their waivers, there's a waiver, not taking it through the school, but if you use the waiver, then that opens your right to arbitrate within that situation. I just think that if the only basis ACT is using is some statistical data, no facilitator or proctor of the examination caught them cheating, no one reported them cheating, you're just saying there's no way possible this student can go, this little black child can go from this score to that score. I I don't know. I just think we're leaving ACT too much broad range to continue to do that. And you're being paid by the government to administer the test. So I think there's a different argument there. I don't know.
I'm in agreement with you. Again, my experience has been, as an educator, I do agree that a student's ACT score, because the ACT is allegedly, I'm going to use that word allegedly, a showing of a kid's overall achievement, or not achievement, but what they've learned overall in school. I do think that schools that service, I know that schools that service high minority populations do not do as well on the ACT as students who come from affluent school districts. Now, that has nothing to do with those children's intelligence or academic ability. But remember, going back to one of the cases that we talked about, the San Antonio Independent School District case, that's one of the reasons why the families sought to have the Texas funding law declared unconstitutional. It's a fact that students who attend schools that attend under-resourced, underfunded schools don't do as well academically, or not. It's really an idea of being exposed. They're not exposed to a lot of things, as many things. It affects them when you're talking about the ACT scores. And if that same score is then used to either allow entrance into college, or prevent a child from being entered into college, I do think I think it's racist, but I think it's racist in terms of I think the more important issue is the socioeconomic status of that child, and how that impacts their ability to transcend the circumstances. If anybody's interested in this particular conversation, if you Google a concept in schools called socioeconomic diversity in schools, you'll start to see how the socioeconomic integration of children in schools is something that's used now to segregate schools. If you look at the city of Baton Rouge, I was the principal of Southern Lab, I was the director of Southern Lab, I was the principal of Lehigh, and I'm actually the person who created the new school. When you look at the fact that there's only one academic magnet school north of Government Street, those factors are being used to create public schools, either through traditional school districts or even charter schools that support only those people from certain socioeconomic backgrounds. And it's done for affluent communities. I know in New Orleans, the best charter, all the schools are charter, but the best schools in the city are the 3 or 4 schools that are predominantly affluent people, and there are charter schools. And that's when you hear people talk about the data, the good data that charter schools produce, they're only talking about those schools. It's a very, very interesting topic. It has a lot of what's going on with the city of St. George pull out effort, and they're wanting to have, a better school, and leave East Baton Rouge Parish School Board holding the bag financially with the legacy costs. Prior to me coming to Baton Rouge, it was the same thing with the Zachary School District pulling out, same thing with the Central School District pulling out. All of these issues are related to people's socioeconomic, their desire to segregate schools socioeconomically. If anybody would like to contact me regarding these issues, again, I'd love to talk. This is my passion. I do practice in other areas, but if you want to talk for a good 30 or 40 minutes, you catch me at any time, and I'm always willing to be a part of that conversation.
Thank you very much for your time and talking to us about this very important aspect of the law. Does anyone else have any questions? Okay. No one else has any questions. We are going to end for today. Thank you all for joining us. Averil, I will be in touch with you soon. Join us tomorrow morning. I think the first session is successions practice, if I'm not mistaken. So thank you again.